Let's move over to Cape Town now. Public Protector Mkhwebane argues an impeachment against her would be a violation of the Constitution. She's tried numerous times to stop the process today. Today is the first day into the impeachment inquiry into her fitness to hold office. To look into today's proceedings, eNCA's Lindsay Dentlinger joins me now. Lindsay, perhaps just speak to us about what some of the arguments are that have come out and what the committee is grappling with on the first day of the impeachment inquiry.
Well, Heidi, a lot of today and most of this afternoon, really, we're on the sticking point of the protector's suspension. She is represented here today by a legal representative, Mpofu, who is really telling this committee that he is not that it can distance itself from the suspension. It's the argument of this committee that it is not their prerogative to suspend her. They never asked anybody to suspend her. It was really up to the president. But really questioning, and this line of argument is continuing as we speak about why the president took the decision to suspend her. We have at least one MP, the UDM's Mkhwebane, suggesting that Parliament get a legal opinion as to what bearing her suspension has on the continuation of this inquiry. He is of the view that if we don't sort out this inquiry, is not going to be able to continue in the manner that we expect. So that's really been a sticking point here today, and the public protector really saying that she has been sabotaged in preparing for this inquiry. She's been locked out of her emails for several weeks and couldn't do her job to prepare for this inquiry, all due to her suspension. So that's really a central argument that has really been forwarded for several hours now before this inquiry. Let's take a quick listen to Mpofu earlier today in arguing that point.
Not only is this suspension premature, as I've explained, whether you agree or not, but let's call that the prematurity ground, or ultra-virus, another Latin phrase, unnecessary Latin phrase. But it is also, it offends against the rule against bias, in the sense that the person who did that suspension is a person who's being investigated by the public protector. And our courts have said that that is bias or potential bias, or, which is more important, a breach of Section 96(2)(b) of the Constitution. That's why we had the Zondo Commission. I was in that case. I argued vehemently that the president cannot appoint or select the judge who's going to chair the commission. And we did that successfully.
Now, Lindsay, how has the committee responded to Mpofu's claims?
So we had very brief opening statement from the evidence leader, who I should point out are independent advocates from the Mkhwebane, starting this inquiry today, saying that this was inquiry. They were here to look at whether the public protector is guilty of conduct, whether she is incompetent and not and fit to hold. They were not here to go through and rehash these reports that are the subject of much of the contention. And the reason why we're here today was not here to rehash the facts of these, but rather to determine how the public protector arrived at these reports, how she had gone about doing the work, what the involvement of the staff were in getting to these reports. And so she was quite unequivocal that this committee was to even determine whether the public protector should be removed from office. It's not their job to decide whether she gets removed from office. Theirs is to consider the evidence before them. That matter, should it come down to it, will go to the National Assembly to vote. And incidentally, Heidi, telling this committee that should that come to pass and it comes down to a decision on whether she should be removed from office or not, that vote is done by secret ballot. But here's Advocate Nasreen Mawar teaching out the parameters of this.
Given that this is the first impeachment process, it is important for us to all have a common understanding up front as to what this committee is and what it is not. It is not a court of law. It is not a quasi-judicial process or an adversarial process. You do not sit as a committee of judges. In regard to the issues with which this committee is seized, it is bound by the judgments handed down by courts of law and which are before this committee, as is anyone else, and it has neither the power nor is tasked with rewriting those judgments. It is also not tasked to assess a criminal conviction, and these are not criminal proceedings. There is no accused, and there is no one that has to plead guilt or innocence. The committee does not have final decision-making powers. That power rests with the National Assembly, that adopted rules to create this committee precisely to deal with the process of the removal of office of, amongst others, the public protector by providing a procedure for consideration of such removal. A procedure which takes cognizance of the fact that it should not be an easy feat to remove a public protector. In addition, these procedures confer on the public protector important procedural rights and define the limits of the committee's powers and functions within the Constitution and the rules of the National Assembly.